Very good evening, everyone. We welcome you to our series on Legal English webinars. And the series that we have this fall is dedicated to the language of IP law. I'm very glad to welcome you. And today we're going to speak about contracts, licensing, and rights assignment. And we're very glad to welcome you to our second webinar from this series. And last time we started this series, and we were very happy to do it. And I would like to introduce once again the main star of our series is Professor Dan Sloan. I would like to introduce him in more detail and to speak more about him so you are familiar with the person who is doing so much for us. Not only in this series, but also in our previous series that we had with him. Dr. Sloan is an associate professor living in California. He is a former Georgetown University fellow, and at the moment he is an adjunct professor at Pepperdine University Caruso Law School, which is in California as well. He specializes in LLM programs and Master of Dispute Resolution programs, and he teaches legal professionals, academics, students, scholars at the Strauss Institute for Dispute Resolution, one of the most renowned school in this area of law. He is also an associate professor who teaches business administration economics at Simpson University. And also he is chair of the business department and director of the MBA and MAOL programs. During his international services, Professor Sloan spent almost a decade in China, Laos, and Southeast Asia, where he educated and consulted the senior staff of foreign governments. And in general, just a second, so I have a big list, his also entrepreneurial experience and professional business career include decades of business with Fortune 500 companies, including Procter & Gamble, Citibank, Microsoft, Philip Morris, Coke, and others. And we're extremely fortunate to have you, Dan, with us. Thank you so much. And we welcome you to this evening. And also just a couple of more moments. We are very fortunate that out of this series on legal English webinars, this is already the 6th series we have at the moment. And Professor Sloan was doing the very first one 2 years, almost 3 years ago, which was really great. And he was the pioneer of this program. We had almost 8,000 participants, and Dan was a star there. And we're extremely happy that we have you again for this series, which is much more specialized on IP law. Thank you very much, Dan. And the floor is yours.
Well, great. Well, thank you so much. It's an honor to be here. It truly is overwhelming and a real honor to do it. So we have a presentation last week or the week before. Now we're heading into another area. We're using this software, and the software is called AHA, and you'll see up in the right-hand corner up there on your screen, AHA, that the software requires or at least provides the opportunity for us to use a voting type system. You know a little bit about me from my previous introduction here and others, so I won't talk about myself, but I do want to head into our presentation. So the QR code we have in front of us will lead you to the presentation you see and the opportunity to vote. And below that, if you can't get through on the QR code, use that ahaslides.com 5FZ8S, and you can log in that way. So we're going to talk about that system and the way it works a little bit, and the way that you can vote. Let me see if I can get a change here. There we go. And there will be little problems here and there, but we'll address them as they come. And I understand that we also have another system set up through Telegram, so that you can communicate through Telegram to Sophia. She is excellent in providing that input. So a little bit about myself, you've already heard. So we're going to begin on like we did last time with a little bit of background, and we're going to talk a little bit more about how the system works so that you can vote properly and give it a try. The issue or the situation that we're going to speak about this week is on IP contracts, and I have a checklist here that we're going to go through for licensing and rights assignments. If you have problems in getting through, you can get a hold of Sophia through the Telegram, and we'll provide you whatever assistance you need. But let's just get started. So, what is licensing, and what are the basics of licensing? And we're going to go through the introduction of IP and through this list here. So, understanding essential components and terminology of licensing agreements is crucial for effective negotiation and drafting, especially for those studying IP law in a global context. And as you can see behind me, I have the ocean behind me. That's in Thailand. I used to live right there for many years and just love that area of the world. But America, as most countries today, are doing a phenomenal amount of business and need to set up these contracts. We're using AI more than ever. And we're going to talk about some of those nuances, some of those differences in the way contracts need to be set up. What are rights assignments? Well, we're clarifying the processes involved in rights assignments that aids Russian law students and professionals in navigating cross-border intellectual property transactions more proficiently. In the last conversation we had in the last presentation, some of the students or some of the attendees were asking as to why do we need to have these laws to protect the intellectual property rights, and it's so that we can stimulate economic growth. We can provide for more innovation. It gives incentives and motivation. So we're going to talk about those kinds of protections. And then compliance and enforcement is a real big part of it. So I spoke of my living in Thailand and Laos, and in many areas of the world, the protections are not as good as they are in others. So we want to have a standard enforcement and compliance regimen that we can use. And part of that is here. So it's learning about compliance obligations and enforcement measures, which helps to ensure that licensing agreements are adhered to, minimizing legal disputes and protecting client interests. And that's where we have those arbitral disputes, where we got to go to arbitration or mediation because we have somehow we have a dispute. So we're going to talk about that. How do we enforce it? How do we ensure compliance? Essentials or essential elements of the IP licensing agreement include the scope of the license. So clearly define the scope, the rights granted, clearly define the rights granted, including geographic limitations and field of use, to avoid disputes over unauthorized usage and to protect intellectual property. So we want to protect it from being broadcast or being disseminated in countries to where maybe we don't have an agreement in order to protect your rights. Because once it goes into those other areas, we lose control over it. So we want to define that properly. Payment structure. So we outline the financial arrangements, including royalties, upfront payments, milestones to ensure clarity of compensation and to align expectations with the parties. So we will set different times and dates, a structure, like a schedule, to ensure that payments are made properly. And then the duration and termination. How long will the contract be, basically? And we're going to specify the duration of the agreement and conditions for termination to safeguard against prolonged obligations and to allow for periodic review of the contract. Revisions. Okay. I'm going to wait for you to join. So if you will scan or join on the AHA slides, there we go. Some people are joining.
Mm-hmm. So as you can see, you can join at via either QR code or you can just print into your phone. the website, and you just need to type in your name. This is how we will understand who you are. And as you can see over here, we have a really big amount of people who are joining us. We cannot see how many of you are viewing us because we already have like 2 screens and we have like Telegram, presentation, Zoom open, where we both are. So that's why the only participants we can see your names up on the screen, which is great. And we are very, very happy that we can use this software. Can I call it like this, Dan? So
The platform.
yes, a platform. Yes, interactive platform, because it really brings in our interaction. And we loved it last time. We tried it for the first time, so we had some technicalities involved, but we'll see how today it goes. So, and we'll see. Okay, we have got 41
Okay.
player ready. Let's go.
Let's go ahead and start. So, quiz question.
Oh my.
What is the one key advantage of drafting clear intellectual property licensing agreements? And I gave you a little extra time on the first one so you could get used to it. I did not choose the music.
So actually, I cannot see the music. There was some guitar playing at the very beginning, but now there is nothing. So at least in my earphones. So maybe you can hear something.
I can hear it.
Okay. So, and let's read out if someone cannot see. We don't know. So let's read out what are the options.
The first one is they replace the need for dispute resolution mechanisms. They are legally binding and can be disregarded during negotiations. They eliminate the need for any compliance checks. They guaranteed unlimited use of intellectual property, and they enhance the potential for revenue generation. So,
Okay.
I'm gonna turn off that music, if possible. Okay, looks like we had a few people get this one correct, and we were essentially testing the system to make sure that it was functioning properly.
Oh, I can see in the top left corner, there is the music. Yeah, now it's turned off.
Got it. Okay. So we have, they can enhance the potential for revenue generation. So what is one key advantage of drafting clear intellectual property agreements? Is increasing your potential for revenue. So they do not replace the need for dispute resolution mechanisms. We still need those in case there is a dispute. So maybe it's clear to us, but something happens and we're not aware of what that dispute might be in advance, or we would probably try to prevent it. But that is why that one's not correct. And they guarantee unlimited use of the intellectual property without, and I don't have the rest of it out there, but it does not guarantee the unlimited use, or they eliminate the need for any compliance checks. We still need to make sure that we have compliance along the way, those checkpoints, and to ensure that everybody's getting paid properly. They are not legally binding and can be disregarded during negotiations, which is obviously the more clear that we have it, the better, not the worse. So that's opposite. Okay. So let's move on to see who our winner is so far. It shows ID. So whoever ID is, you're up by 91 points so far. All right. Good job. So clarifying rights assignments in contracts. How do we do that? How do we clarify them? First off, we want to define ownership rights. Outline who owns the intellectual property after the contract is signed to avoid disputes and to ensure all parties understand the ownership landscape. And that can be a problem if we don't do our due diligence, that we're not checking to ensure that the property is actually owned by the person selling it. Okay, so very important. Specify usage permissions. So we want to detail how the intellectual property can be used by each party, which prevents unauthorized usage and maintained control over the asset. And it would reduce the need for dispute resolution because we would be more clearly identifying those rights. So I'm going to give you another one here real quick. Here is a concise scenario about a licensing agreement, including a multiple choice question with answers in both English and in Russian. Okay, so we're going to try it here in English first. GreenTech licensed its solar panel technology to EcoHome for residential use. The main negotiation issue was the royalty rate, with GreenTech proposing 7% and EcoHome countering with 4%. They agree on 5.5 after discussions. So the question is, what was the main point of contention during the negotiations between GreenTech and EcoHome? It's the same question. More music.
Well, I cannot hear the music, so that's fine.
So A is duration of the agreement.
Oh, no. No, now I can see it. Now I can hear. Yes, it's a little bit guitar something.
Yeah. I would love to cut that off. I'll have to figure that out.
Oh, there it is. There it is. It showed up, so you can turn it off probably in the left top corner of the presentation itself. No. Just the blue screen, and you can see that in top left corner. Yeah, so maybe, yeah.
Okay. You were seeing that. That would bother me the whole time. So B, geographical scope, C, royalty percentage, D, confidentiality terms, or E, patent ownership. Which one is the correct, or are there more than one? That's a trick question because in the future, there probably is only one answer in this one, but in the future, there may be more than one answer.
And we actually have received a question. So I will ask after we look at the...
Very good. Very good. So royalty percentage. That's what we're discussing there. I just want to make sure that I have everything clear, that you can read it and it's explained well. It looks like I've done a good job, and you have done an excellent job of answering this.
And I did receive a question actually through a personal message, not in our chat, or on Telegram. So the question was that obviously someone is not that familiar with IP law, so it's a very general question. What is the difference between assignment and licensing in very plain English? How would you explain it?
In licensing, we're renting. In assignment, we're selling. It's kind of there's more to it than that, but that's kind of more simple terms.
Okay, thank you very much. So it means that if Stack Corp assigned, it means that it's fully sold its patent, yes, for a new battery to Energy Solutions.
Correct. So we're going to look at this more deeply about the differences between the two. So we're gonna talk about that more, but just very, very simply put.
Thank you very much.
Welcome. Okay, so you guys did really well on that one. And ID, you're falling a little behind, but you're doing well. You got 82 on that. So how this scoring works, since we are looking at this, you will see where it shows Ivan has 182 plus 97. 111 has 175 plus 93. The reason why Ivan has more points is because he answered it faster. So it's not only that you got it correct, but if you are answering it faster than everyone else, then you receive more points.
Oh, so we have full gamification here.
Full gamification. So the faster you answer correctly, the more points you will receive. Okay, I move on. Another quick one here. And this one is on IP rights assignment, including a question with multiple choice answers. So in this one, Tech Corp assigned its patent for a new battery technology to Energy Solutions. The agreement included a clause for ongoing royalties based on sales. During negotiations, the main issue was the royalty percentage, with Tech Corp wanting 8% and Energy Solutions offering 5%. They settled on 6.5. So I don't know if we can see the question there. Kind of hard
No,
to,
but maybe you can just, maybe if
well,
you move the next slide, we'll see the question.
and we will. Good point. Oh, maybe not. Okay, something's gone wrong there, but we'll get to it in a moment. It'll come back to it. So let's just look at this for a minute and we'll come back to that. Ensuring IP license compliance and enforcement. So how do we ensure that we have intellectual property right license compliance, and then how do we enforce that? You know, we spoke about this in our last session, and people wanted to know, well, how do we enforce these international agreements? And we use various organizations. We have various remedies that we turn to, and treaties. If you remember, we spoke about that quite a bit. Some of the other things that we do are regular audits. So we implement scheduled audits to verify compliance with licensing terms to ensure that what we're doing actually is in compliance with what we've agreed to. We have performance metrics. So we establish clear metrics to monitor compliance. That means we want to know how many number. We use statistical analysis and data to confirm that we are reporting it correctly. Effectiveness in enforcement to ensure that what we're reporting is being paid for properly. We have legal remedies, which define the remedies for breaches to deter non-compliance issues, which might mean that maybe there's a penalty for non-compliance. So they may pay a fine, or maybe there's a cap on a number of items that are produced, or something to that extent. On intellectual property, it may limit further use of that property, for example. We have obviously ADR, alternative dispute resolution, which is also another legal remedy. And training programs. We conduct training to educate all stakeholders on compliance obligations. So we want to ensure that what we are communicating matches what we believe to be correct, that we have the meeting of the minds in the legal terms. So importance of IP contracts in law is risk mitigation. We want to reduce the risk through proper IT contracts and reduce the potential for legal disputes. As we know, that the disputes cause a lot of financial problems as well as disruption in our relationships with our clients. Revenue generation. Licensing agreements create new income streams from intellectual property. The clarity of the rights. The contracts ensure all parties understand their rights and obligations. In market value, IP contracts can enhance the overvaluation of the business. If we know that we have a revenue stream that we're generating both income and profits, obviously we can translate that into a higher market value. And then enforcement tools. And we want those well-crafted contracts to facilitate easier enforcement of IP rights. So those are some of the aspects. So the correct answer on the question I had, these might be out of order. And some of the use of the new software is that we're finding that I write faster than it will save. So
that's okay. So if we just imagine that you are like across the Atlantic Ocean from us and 13 hours time difference behind us. We're in Russia, you're in United States, and you're asking questions we can answer. So there might be some technical issues. They don't matter. So we're experimenting.
If you recall, when you're online, sometimes you'll have the buffer, the little thing will turn.
Yeah.
It's waiting. Well, during that time, it can mess things up to where they're out of order. So this happens. So that's where we're at. So that gave me an answer to that question. We may have another question here coming up. Let's take a look at this one. This might be the one we read earlier, but didn't get to answer yet. Let's check it out. Yep, this is the green tech.
Mhm.
Same one.
Oh, and it gave us already the answer. So I
This is,
remember. Yes.
yeah. So we've
Hmm.
already had that one. Let's move on. So the royalty percentage um, is the primary issue during negotiations was the royalty percentage. Tech Corp wanted 8, while the Energy Solutions offered 5, leading to a compromise of 6.5. Okay, so the key elements of an IP contract, what are those? Okay, so the key elements are the parties, the scope, territory, and duration. The parties identify the contracting parties with their full legal identities. The scope, which clearly defines the scope of rights being licensed and assigned. Territory, specific geographic area where the rights apply. And a good way to really review this or to think about it is Netflix is a good example, an American firm company that produces Hulu, Disney. They're all over the world, but they all restrict those rights for rebroadcast to various countries or areas of the world. They all do it for various
Hmm.
reasons, but that's the territorial issues. Another way to look at that. Duration, establish a clear timeline for the contract's validity. Compensation, how is it going to be paid? Okay. Online payment terms, including royalties and fees. The confidentiality include clauses to protect sensitive information exchanged. So that sensitive information, as we know today, is becoming more important because of AI and the ability to dox, what we call dox someone, which is to put information out there about them that may not be, that's private, credit card information, people's home address, their children, many things. So we want to protect that kind of information as well. Dispute resolution. So the mechanisms for handling potential disputes, ADR, so your mediation and arbitration, as well as potential litigation would be another way to, but that's going to an extreme. We hope we don't have to go there. Governing law, we want to specify the applicable legal jurisdiction for the contract. And that would take some homework or research in order to perform, in order to know where we have a valid legal jurisdiction that'll apply in the event of a dispute. So let's go and see if you have another one here. Who wants to win on this one? Which of the following is not an essential element of IP licensing agreements? Confidentiality clause, moral rights inclusion, duration and termination, payment structure, or scope of license. These are some new terms that you may not know. Let's see how you do.
And I would also like to thank Dan because he prepared some extra exercises and he sent them to me. And after the webinar and until the next webinar, I'm going to post them on Telegram and other social media so you can practice more. So we're going to revise the vocabulary plus do some exercises on the first webinar and on today's webinar. So there will be really, for the first time, we're doing this when we have some inter-webinar interaction and extra, I wouldn't say home task, but revision. Let's put it this way.
Yes, very good. Wow, we had most people get this correct. So a moral rights inclusion was not listed there. So confidentiality, we mentioned, duration and termination, the payment structure, and then the scope of the license were all included. The one that was not included was that moral rights inclusion. And the moral rights inclusion might be something that is in a region, a country, or due to the entity that you're performing the contract with, one of the parties may have some moral issues that they want to include in the contract. And if it's legal in their jurisdiction, then we might include that. But that was not included in our licensing agreements information here. So let's see who's in front. Ivan, you're out front again. 372. Looks like we're having a better use of the system this time than the last time. So that's good. So types of licensing agreements, and I put this into a grid so that you can take a look at it. The type would be an exclusive license for a license agreement. And the definition of that is a license granted to one entity only. Key features are full control for licensee. Advantages are high potential revenue, and disadvantages is limited market reach. So if you have a license that you want to get out there and you enter into an exclusive license with a client, that it narrows the use of it potentially because it's only going to be exclusively used by one. The non-exclusive license is a license granted to multiple entities. Key features are wider distribution of rights. Advantages are lower entry barriers, and disadvantages are the potential for revenue dilution. It means that revenue dilution means your revenue may be lower because you have multiple partners that are distributing this content and probably competing against one another or others, so the prices might be lower. Sole license. So license granted to one licensee and licensor, the licensor retains the rights. Key features, it combines exclusivity with certain rights. Advantages, it's flexible in its rights management. And disadvantages is the complexity in rights enforcement. And then the last one here is open license, no restrictions on use. Encourages innovation and collaboration, high scalability, risk of loss of control over the IP. So that one where you're just putting it out there for everyone to use in kind of the world, the internet access to everything.
And can I ask a question, please? And what does it mean? Oh, scalability.
Scalability is what you want to do is get it so that it's larger and larger. I'm going to use Netflix again as an example because it's so large. What they want to do is license. If they produce their content, then they're basically creating it on their own and using it. But a lot of their content they have to purchase through a licensing agreement. So they may have an agreement with one of your favorite TV shows that has a series. And so they'll purchase that license for 3 years, for example. Okay. If the person who owns the license, let's say it's Disney, sells the licensing agreement to Netflix, if they want to have it scalable, if they want to get it out there further, they need to go with Hulu and Amazon and a whole bunch of others as well to get it larger. So scalability is just trying to ensure that with your intellectual property, that you're taking into consideration how far you want it to reach, and the type of licensing agreement may impact that greatly.
Okay, thank you very much. So it's kind of from scale. And we have one more question, actually, from Daniel through Telegram. And we would really appreciate if you ask your questions through our Telegram chat, because here we don't have that many options to see the questions because we're afraid to touch the presentation, not to, misuse it or do something. So there's a question from Daniel. Could you please give a practical example of using a non-exclusive license?
Yeah, where it's as I said before, if you think about Netflix, and I'm sorry if it's difficult to understand that one, but if the company MGM, okay, which is a large production studio, and that might have been bought by Amazon, they're all buying each other for this exact issue because they want to keep those rights. So in an exclusive license, the producer of the content may give an agreement only to one company, Netflix. So then they have to depend on Netflix to get the content out. The benefit to Netflix is they don't have to compete with other firms with the same content. It's only exclusive. With non-exclusive, it means that you're licensing to multiple providers. So multiple companies will provide that content for you. that can be a good thing for wider distribution and to get it out there. But the potential for revenue, like it says, is diluted because now we have people competing with the same content. Okay. So
Okay.
non-exclusive means that we're not going to only give it to Netflix. If we have a really famous or popular video, for example, we might license it to Hulu, to Disney, Amazon, and Netflix. Maybe they won't want that. Maybe they will say, we only want exclusive because we don't want to compete, right? But the non-exclusive would be good. So if you have let's say you have a book or a text that you want to put out there, you would probably want to sell it at more than one platform. Only Amazon? No, you would want to go with many. So then you would have a non-exclusive license. You would still want to get paid your royalty, but you would have a non-exclusive license. So it depends on the situation.
Okay, thank you very much.
Okay, so we have another question here. Everybody's jumping on. Ready? Okay. Which key element is essential to include in an IP licensing agreement to define how the licensed intellectual property can be used? Confidentiality clause, the payment structure, the governing law, party identification, or the scope of license. Some of these are very difficult. So which key element is essential to include in an IP licensing agreement to define how the licensed intellectual property can be used?
So they need to choose only one, yes, as I understand.
Correct.
And we have one more question, but I will ask after this game is
I added a little more time this time.
and we're very grateful to you because we do have a little bit of this delay and it gives really time to think. It's excellent.
All right, let's see how we did. There we go. You did well. Scope of the license is what's important here because we said how the licensed intellectual property can be used. That was the important part. Very good. So what was our question?
Yes, there is a question for Dmitry, again about the difference. Could you please explain the difference right now, maybe some practical example between sole and exclusive license? Because very often in Russia, people translate it identically, not understanding that there might be a difference between them.
So let me go back to that slide.
Yes, sole and exclusive. Yes.
So the definition, let's go back to those first. So exclusive license is license granted to one entity only. In under a sole license granted to one licensee and licensor retains the rights. Okay, so they retain the rights of that property. The key features is that full control for the licensee. Okay, if you see under sole, who retains the rights? The licensor. Do you see that?
Yes. So, and it means that in an exclusive license, the licensor does not retain the rights. So they're like given, but then it would be assignment. No, I think that is.
It's a little different. Yeah, and that's the technicalities to have this. So it combines exclusivity with certain rights. So you do have exclusivity, but you don't have full control. And it would depend on the issues in the agreement as to what that means, what controls you would have.
Okay, so it's like a subtype of exclusive license, sort of.
Yeah, that flex is because of that combination. But you may have certain reasons why the licensor feels that they need to retain control. And without that option, maybe that would not be possible to have that kind of an agreement. So it gives a little more flexibility to the licensor to say, I don't want to lose all control.
Okay, thank you very
We'll look
much.
at what assignment means. I hope that helps. Okay. We already did that one. Let me see if this is something different. Oh, no, we did that one. Ivan is still in the lead, it looks like. Okay, and then I put this in Russian so that you have it. Maybe it'll help explain it a little. I kind of thought that
Thank you.
this would come up, this question.
Thank you
So,
so much.
you're welcome. So that'll be part of the presentation. I'll make sure that you have a copy, Sophia. So
Thank
what
you
is a
very
key
much.
advantage of exclusive license? Here we go. In IP agreements. Lower entry barriers for licensees, encourages innovation and collaboration, combines exclusivity with certain rights, wider distribution rights, or full control for the licensee. So let's see who gets this one right after we just had some very good discussion of the details on this.
And we already have some more questions popping up, like one question. So, and we'll just wait.
20 seconds.
And it's actually, I think that's the most comfortable time, when it's a minute or a little bit more than a minute, because it gives really the time to think.
And that delayed.
Yeah.
We have technology and then the translation. All right, good job. I like it. After we went through this, you accurately pointed that out. Full control for the licensee. So the sole license does not. Remember, it has that combines exclusivity with certain rights in the middle one. Let's see who's ahead now. 564, Ivan, you're still up there. You're answering them quickly and accurate. Okay, one more here. Oh, maybe not. Okay, so now we rights assignments. Did you have another question for me? Or
Yes, there was a quick question from Irina. Can a license agreement be concluded for an indefinite term? And are there any legal consequences as to US law in this situation, if it's possible? If you know.
I'm not clear on a situation where you would not. A term is important to have, even if it has a renewal. And we're going to go into that in a few slides from now. So let me kind of hold off on answering that so that I can give a better explanation with a graphic that'll show you what I'm talking about.
Super, thank you.
All right. So rights assignments, definition and the importance of rights assignments. So a little bit different. So we're ensuring all rights assignments are documented clearly in IP contracts and eliminate ambiguous and protect ambiguities and protect the interest of all parties involved. This practice not only fosters transparent relationships, but also safeguards against potential legal disputes related to the ownership and usage rights. That's a mouthful, but what does it mean? Understanding the intellectual property rights. So what is rights indemnification? We're going to go into these in a moment. I just want to get a little more clear on what the terms mean. Rights identification. So to identify all intellectual property rights relevant to contracts to safeguard ownership and usage, identification. And then licensing agreements, draft clear licensing agreements to outline scope, duration, and limitations of IP use between parties. Infringement consequences. So understand the potential legal consequences of IP infringement to better enforce rights and seek remedies. And contract clauses. So incorporate essential clauses in IP contracts addressing assignments, subleasing, and termination procedures. That's some of the stuff we're going to get into in a minute. You're just asking the question about. So in licensing terms and conditions, we're going to put in the scope and define the specific rights and limitations of the license. The territory, again, we spoke about this a little bit, but specify the geographical area where the license applies. Termination, which is important, that we have that as part of that earlier unlimited kind of consequence. Well, if it's unlimited, how do we terminate it, right? So we're going to detail the conditions under which the license can be ended. And then assignment, state whether the license can be transferred to another party as well. So the duration, the length of time the license remains valid. Okay. And that could mean under specific circumstances that we're going to have a very long duration or an infinite. We'll have to look at that in a moment. A royalty, outline the payment structure for the licensing agreement. The use, clarify the permitted uses of the licensed intellectual property. And warranties, includes guarantees regarding ownership and the rights of the intellectual property. So warranties might include something to where you are going to indemnify others from harm if you are the licensor or licensee. You're going to protect the licensor from loss. Another quick question for you. Oops. Start that. Which of the following are essential components of the IP licensing agreement? Is it termination and renewal conditions, number of parties involved, governing geography, payment structure, scope of license? So which of the following are essential components, plural, of the licensing agreement?
So there can be several options here, as I understand, yes?
That's why I said it can be tricky. But if you read the question correctly, it's asking you for components, plural.
I'm giving out something, yes, I'm sorry. Happens.
Termination and renewal conditions, number of parties involved, governing geography, payment structure, scope of license.
Okay.
Okay, so we had the termination and renewal conditions, the payment structure, and the scope of the license. That is correct. Scope, territory, termination, assignment. I think we've already got that. 0, 0, 0. Well, some people did well. So scope of the license, we're going to go through these very quickly. The scope of the license and usage rights. So grant specifically clearly defined the extent of the rights granted, including limitations on location, duration, and purpose to avoid misuse in unsure compliance with the license. So specificity. Transfer provisions, which outline the conditions under which rights may be transferred to sublicensed, ensuring that any sublicensee adheres to the original contract terms. Oops. Are you ready for another one? So what are the following essential components that should be clearly defined in IP licensing agreements? Marketing strategies, preferred language of all parties, duration and termination conditions, compensation conditions, or the scope of the license.
And can I ask a question while we are waiting for an answer? Because we sometimes have a dispute with our students at the classes related to, is there any difference between assign and transfer? Because sometimes they're used as synonyms, pure synonyms, and sometimes there might be some difference in usage. So there is always this dispute. So
it would get down to the nuances of how you're using it. So there is a difference between assignment and transfer. You'd have to give me an example of what you might be using it in.
Yes, so I will just wait for this, and I can give an example later on.
Very good. Wow, you guys did great. Yeah, the duration and termination conditions, compensation terms, and the scope of the license. So where that could fit in, I don't have a precise example for you on the question you just gave me between assignment and transfer, but it would depend on the scope of the license
Yeah,
as
so
well.
because sometimes they can be just different, as we can read the clauses from contracts from abroad. Very often it's used interchangeably. Sometimes, for example, in Russia, it can be a difference. For example, if you can have a contract which is called assignment, but if you are giving both, for example, rights and obligations, then they would use the word assign. And for example, if you give to the other party only the rights, it's like limited. So then
Right.
they would use the word transfer. So we've seen these situations because that is the approach of the like Russian based lawyers. Or sometimes I've heard also the situations when some people would say that you would use assign with non-tangible assets and transfer with tangible assets. So there are like maybe just linguistic nuances or something like this, or maybe we're just trying to find specifics whether or none. So that's why there is common question from many people. So
Yeah, I think that one's likely going to be dependent on that last issue here, which is the scope. That would
okay,
bring up all of those issues, whether it's tangible intellectual property or, um, like you said, what kind of rights are involved or included in that scope.
yeah. So it depends on like specifics. Okay, thank you very much.
Ivan's still up there. Do you know Ivan?
No, actually, I have no idea. Well, I do have several ideas who this Ivan can be, but you never know because at the moment we have almost 2,000 people who got registered for this webinar. So I understand that not everyone is watching because we have got 9 time zones, people work and so on. So we're very grateful to those who came, and it's fun because it can be anyone. But Ivan, then Natalia, I do have an idea who Iraida is because I know one Iraida. So anyway, it's great to see familiar names, and we're just so happy that we have audience who are interested. So thank you, everyone.
Thank you. So we have question 10. Which of the following elements is not essential in an IP licensing agreement? Is this the same one? Hopefully not. Social media presence. This might be a duplicate. Confidentiality provisions, duration, termination, payment structure, and scope of the license. This might be a duplicate.
I think it's a duplicate. Yes, it sounds like it.
This is not essential.
Uh-huh.
Maybe it was essential. This
Yeah.
one might be not essential. So
we're
ahead.
making everyone being very attentive.
I like it.
Yeah.
This one's easy, but I mean,
It's like targeting from every possible perspective.
yes.
And for the first time ever, actually, we did use some software before, which was interactive, but only AHA slides give us the option of having a competition.
Yes.
This is fun.
Oh,
So,
great
yes.
job. Boy, you guys did very well. That was important there. Social media presence. We already gone through the rest. So let's see who our leader is. And it's still Ivan. He's still up there. And another quick one. I think I had 3 or 4 in a row here. Which of the following is an essential element that should be included in IP licensing agreement? Conditions for termination, preferred payment methods only, a detailed list of employee names, personal preferences of licensor, and geographic area of usage. Is an element.
It's tricky. I would say 2. I would choose between the 2. So that's very, very tricky.
Well, you are doing much better than I could in your language. So
We're enjoying it so much because it's like doing crossword in another language. And It makes your brain boil sometimes.
Yeah. Ooh, there you go. We had two answers. Are those the two you were thinking? Conditions for termination and geographic area of usage. Personal preferences, the licensor are irrelevant. A detailed list of employees, we don't really need that, nor do we care. Preferred payment method only? No, we don't need those. And still Ivan, but it looks like Dan pulled up a little closer this time. We're going to look at the jurisdictional aspects of IP contracts. So the governing law determines which law applies to the contract. We have the venue and jurisdiction. So it specifies where disputes will be resolved legally. Enforcement mechanisms covers how rights will be enforced in disputes. Very important part of it. International treaties, and number 4, influences on contract terms from global agreements. Number 5, local laws, impact of domestic laws on contract validity. Number 6, conflict resolution. What are the methods for resolving disputes without litigation? Mediation, arbitration. Cultural considerations, understanding the influence of culture on contracts. And all of these can have a big impact, so very important. So which element is crucial to include an IP license agreement to prevent disputes? Ready? Confidentiality clause, geographical limitations only, duration only, parties involved, or scope of license. We're coming at it from many different perspectives. Which element is crucial to include in an IP licensing agreement to prevent disputes? I'm not the Dan that was on there, by the way.
Yes, and I'm like thinking. So, okay, so which element is crucial? And again, we have people who give more answers, so more than one answer. Oh, there can be.
In the scope of the license. So who are the parties and what's the limitations? What is the scope to prevent? The duration only? No, more than that. So very good. Ivan took him a little longer. I could tell, but it's 86 instead of 90s. So he took him a little longer to consider that one. So here's some of the issues I was talking about earlier, where I put a grid in here about the duration of a license agreement. So under this grid, you'll see it starts to define the term January through July. Renewal terms. So we have the prearrangement in our contract that we're going to begin in June to renew the terms of the contract, to renew the terms of the agreement. Termination conditions through March through June. This is called a Gantt diagram that we have here. It's used a lot in engineering and other types of scheduling. Termination conditions. Then we're going to have duration impact, which would be April through July. Maybe there's an impact that we're scheduling for something to occur. We may have the license agreement in place in January, but the impact of the license is going to take effect April through July. Okay, makes sense? And then jurisdictional variances. So we may look into what the differences might be in how we agree to further issues in terms of the variances because of the jurisdictional, I guess, oddities or dissimilarities that we have, the variances. Payment structures we spoke about a little bit, but what are they? So we're talking about royalties and fees. We may have a flat fee. Well, let's start with number 1 on top, royalty fees. So understand the structure and purpose of a royalty fee agreements in intellectual property licensing transactions. So you're going to get a royalty, maybe a percentage of the use. Okay. Unlike a flat fee where we're just paying a nominal amount. So analyze how flat fees can simplify payment structures and provide certainty for both licensors and licensees. If we're able to come to an agreement on a flat fee, it does eliminate some of the uncertainty. But at the same time, if we have something that's extraordinarily popular, it may have, like we have on videos that are on TikTok or something, where you have millions of hits instead of hundreds. So we want to make sure that we structure it properly in that regard. Performance-based payments explore how performance-based payment methods align with incentives between the parties while managing risk effectively. What this means, performance-based, might be that we have a certain allocation or a certain amount that we want to hit. So we say, if we sell 100,000, it's for this amount of fee. If it goes to 1 million, then it's even a different fee. Okay. So performance means the better we perform, the better the reward or the different structure of the fee basis. Okay. The payment structure.
And there's and can I ask a question? There is a question actually jumping right in with my personal message. So there is a question about this performance-based payment. And the person is asking, can we call such payment an earn-out arrangement like it is done in some corporate deals? That like arrangement that depends on our performance, or this is not the term that will be used?
It's similar. It would depend on the structure, but it's very, very similar. So it provides, like it says, for incentives, aligns with incentives between the parties to say, if you own the rights, if you're the licensor, you want there to be that scalability we talked about earlier. And the greater the scalability, the better it is for both parties. So we're going to give an incentive. And we see that used many times in many different products, both tangible and intangible products that are licensed. So that incentive is there.
Super. Thank you.
Okay, ready for another question. Which of the following elements is not typically included in an intellectual property licensing agreement? Confidentiality clause, duration and termination, personal details of a licensee, scope of license, and payment structure. These should be getting easier because we've had quite a few now. That was my goal, is to, by the end, you would get these very easily. Let's see.
Okay. So I'm already, I'm already thinking that they are on one hand getting easier, but on the other hand, you need to be very attentive to catch the right answer, because there are some specifics in them.
It can be tricky. Yeah.
Yes, that was the word I was looking for.
There you go. You got it right.
Excellent.
30. Yeah, very good. Personal details of licensing, because it says is not typically, right? Getting much better at them. Ivan, up there again. So termination clauses. How do we terminate an IP contract? Breach consequences. Clearly outline the immediate effects upon breach, including rights retention and remedies available to non-breaching party. And that outlines the fact that either party could be in breach or multiple parties. Notice period. Specify the required notice period for termination and any conditions under which it can be waived. Very important as well. We do have that breach and termination. Now we want to make sure that we have a notice requirement. Then post-termination rights. What rights do the parties have after we've terminated the contract? Detail the handling of intellectual property rights after termination, ensuring clarity of ownership and usage. Okay. Dispute resolution mechanisms. In the event that we do have a dispute, how are we going to resolve this? The most obvious, I would think, and the easiest is negotiation. The parties engage to discuss and resolve the conflict. We would then maybe move on to mediation, involves a neutral or a neutral party, third party, to facilitate the discussions. And again, mediation is generally not binding, so we're going to have that as an option. That may be something we would put into the contract, these steps that we might take on the process of getting to the last one, which is enforcement. But where arbitration would be our next after mediation, maybe submit to a binding decision by an appointed arbitrator, which is the difference between mediation and arbitration. Litigation, very costly. Resolve disputes through formal court proceedings. And then after we have an opinion by the arbitral tribunal or by a court, then we would know how are we going to enforce that outcome. So ensure compliance with the decided resolution or ruling. Confidentiality obligations in IP contracts. What do those mean? So what kind of penalties if there's a breach of that confidentiality? And that could happen accidentally. There's many ways that it could be breached. So specify the penalty for breaches to deter unauthorized disclosures effectively. And by putting this in there, you put both parties on notice that if information is confidential information is exposed, how it's going to be dealt with, what kind of penalties might be involved in it. And that penalty would then tell them you need to be accountable to put safeguards in place. The duration clause, define the duration of confidentiality obligations to ensure clarity and mutual understanding. For how long do we need to do that? After the termination of the contract, do we still need to have the confidentiality? And most likely that is going to happen. You're going to want the duration to match whatever desired outcomes or issues are with the contract. The scope of limitation. Limit the scope of confidentiality information to prevent overreach and potential misuse. So we want to make sure that we have in there, here's what we're covering. These are the reasons why, and they are valid reasons. We need to assess control or access control. Implement access controls to restrict who can view confidential information. And ways of doing that are to limit the number of people or limit the positions of people so that that information is not accessed by everyone within the organization. Third-party restrictions include clauses that prevent sharing information with third parties without consent. Maybe we have a subcontractor or somebody within our organization that we have to share some access to, going to number 4 above, but to put a clause in there about how that happens. And then return or destroy. Require return and destruction of confidential information upon contract termination. Very important as well. Mm-hmm. In moral rights in licensing agreements, we're talking about attribution rights. Ensure that the creator is credited appropriately for all uses, just as we do in academia and other areas, to where the person has their credentials cited or they're cited for their works. We have integrity protection, prohibit alterations that could harm the creator's reputation. We have use limitations, define the context where the work can and cannot be used. Another protection for the moral obligation. Withdrawal clauses allow creators to retract rights under certain conditions. That is also another one. It's also called a right of retreat sometimes.
Mm-hmm. Revocation. Okay. I do have got 2 questions. Mm-hmm. So, and actually both of them are from Dmitry, but from different Dmitry. So one is going back to the last quiz that you asked us about the personal information of the licensee, that it is not considered to be, I think, yes, that was the question about not typically included into licensing agreement. The question was about personal details of licensee. Can you please clarify what it means exactly? Because one of our viewers says that name of the licensee may be crucial for the licensor. As I understand here, it means more than the names. Yes? Am I right? Personal details.
Are not typically required. There may be reasons. They're called BFOQs, which is a bona fide occupational requirement for employees or for other reasons you may need to know, but you'd want them to be bona fide. You'd want there to be them to be substantiated as to why we need those.
Mm-hmm. Okay, so it's more than a name. So it's more than a name. It's not.
If you're asking people their ethnicity, their religion, you know, if they're married, how many children they have, information is really not relevant to the contract. That wouldn't be something.
Thank you very much. And there was another question. So from another Dmitry Kizyanov, can the term seed, SEDE, be used in the context of IP rights assignment? So, which does mean like give away, transfer, and so on. So can the term seed or the word seed be used in IP assignment? As I understand, we will spell it as CEDE.
CED.
Yeah.
I think to be more accurate in a more understandable term, assignment would be more accurate. You might be able to use it in some context. I'd have to know what that would be. But I think in terms of accuracy, because once you start entering in vocabulary that may have some vagary to it, is when you, as the author of that contract, could be in a problem trying to define it. You could spend a lot of time and money trying to defend it.
Thank you very much.
I would stay with assignment.
Okay, super. Thanks.
So under moral rights licensing agreements, we went through 4 of those. The 5th one would be local moral rights. So be aware of local moral rights laws affecting the licensing. And in some cultures, Persian, Arabic, you could think of some rights that might be almost in every culture, there are local moral rights, but those are profoundly different in some ways. So contract review, regularly assess contracts for moral rights compliance. Sometimes the issues change. Like in India, there's some big changes in their culture, in the way that their laws are being structured, in the form of government they even have. Dispute resolution, establish clear processes for resolving moral rights issues. If we have a moral rights issue, is that something that can be handled in, like I've had students that are under Sharia law, to where it's handled by a village elder, who's going to handle the dispute of a disagreement of some sort. How do you decide those kinds of factors? Okay, let's go with another question here. The question is, why is understanding judicial aspects important to IP contracts? Why is understanding jurisdictional aspects important to IP contracts? It allows for unlimited transferability of rights without restrictions. It eliminates the need for compliance with local laws. It guarantees that all disputes will be automatically resolved in court. It simplifies the drafting process of the agreement, or it helps determine the governing law applicable to the contract. Why is understanding jurisdictional aspects important to IP contracts?
That's a tricky one. And I wanted to give a hands up that we have 15 minutes left. So, as I'm a timekeeper.
Time's up. Okay. Right on. We have 29 that got this correct. Very good. It helps determine the governing laws applicable to the contract jurisdiction, right? So
Excellent.
the most correct answer anyway. Very good. Who's our leader? Ivan's still up there. So assignment versus licensing. So the key differences, and I think this is where we were going with a lot of this.
Yeah.
So control, assignment, the total transfer of rights. In licensing, owner remains with the assigner. Comments, assignments often are often irrevocable. Ownership, and under assignment, we have limited rights granted. Under licensing, licensor retains the ownership. And licenses can be exclusive or non-exclusive. Duration, under assignment, assignments typically permanent. That was your question, I think, earlier.
Mm-hmm.
And then the duration of a licenses can be time limited, can be. And then assignments are final. Licenses may have renewals. I hope that helps delineate the two. Remember, I was talking about selling or renting at the very beginning. So transferability. Unfortunately, it looks like it eliminated my text. I don't know why it did that.
And I thought that that's purposely made so the our participants can kind of jump in.
We'll probably have a question on this, but I don't know how accurate that's going to be. So we'll take a look at that and see if I've got it on the next one here. No, let's try the quiz and see what I came up with. What do you call it when an inventor needs to share their prize-winning potato chip recipe without losing ownership?
Oh my goodness, Lord.
Sole license, a spud-tastic sharing, is it potato power agreement, confidentiality clause, or an open license? Now, a couple of those are silly, of course, but a sole license, potato power agreement, spud-tastic, confidentiality clause, or an open license. What do you call it when an inventor needs to share their prize-winning potato chip recipe without losing ownership?
I'm really interested what's going to be the answer.
There you go. You have two of them here. Sole license, only I can enjoy these chips. Okay. Or confidentiality clause. It's like a secret handshake. The open license, you wouldn't retain control, right? The owner would lose the ownership. And the other two, potato power agreement, that's just silly. And the same thing with spudtastic. Just give it away. You would not retain control either. Okay, Ivan's still in control. Governing law and jurisdiction clauses. So choice of law, understanding the choice of law provisions helps ensure that the contract adheres to the relevant legal framework, which can influence the liability and rights enforcement. And dispute resolution, which is identifying the jurisdiction for dispute resolution, is critical in determining where legal will be conducted and can affect the outcome of contractual disputes. Drafting considerations for IP contracts. So we want specific terms, geographic limits, payment structure, and dispute resolutions. I'm going to move through these a little bit. We've gone through some of it already. So which one key element, what is one key element that should be clearly defined in an IP licensing agreement? Is it the payment impact, cultural considerations, market value, or the scope of the license? What is one key element that should be clearly defined?
And there's a question actually, which is related to the previous slides about governing law. The question is from Irina: is there any difference between governing law and applicable law?
It would depend. Again, it's the governing law would be what you're going to say is going to be relevant to the contract, which area of jurisdiction it's going to be in. Applicable law might be something that, even though it's not in the agreement, so
But
it depends.
may prevail over and contradicts, for example.
So it depends on that issue. Scope of license, very good. And negotiation strategies for IP licensing. So we build relationships to establish strong connections with counterparties to foster trust and open communication during negotiations. We know your value, clearly articulate the unique benefits of your IP to justify your licensing terms and conditions. Be flexible, be prepared to adopt or adapt your offers and terms based on the needs and capabilities of the potential licensee, and seek a win-win outcome. And that doesn't mean we win and then we win again. That means they win, we win, everybody comes out ahead. Aim for agreements to provide mutual benefits to both parties, enhancing long-term partnership potential. IP due diligence, what to consider. So confirm the ownership. We spoke about that earlier. Confirm legal ownership of intellectual property rights before any licensing or assignment agreements. Number one. Transfer conditions. Evaluate the conditions and requirements for transferring intellectual property rights effectively. License scope. Assess the scope and limitations of existing licenses and any potential infringement issues. And then compliance checks along the way to ensure compliance with local law, IP laws, and international treaties relevant to the rights involved. And this can get tricky in there as well. Another thing that you can do is to review case studies, successful IP contracts, and those are put forward by various journals, legal journals, scholars. What is the problems that are faced? What are the ambiguities in contract terms that caused the disputes? What solutions are offered? So writing or understanding clear contract language and defined rights. And that's why I'm a little bit hesitant to put new terms just to see how they work. I would rather have certainty. And then benefits. What are the reduced legal conflicts and enhanced partnerships when we're communicating very clearly? An approach you might take would be analysis, which would be to review existing contracts for potential issues. And that's always a good place to start. Where are we at now? And then we can build upon that, or decide maybe it's ineffective. We're going to just scrap it and go away and come back with something new and different. We would create new contracts with precise details. Review the conduct conduct a thorough legal reviews and pre-signing, and then implementing. Ensure proper execution and compliance with the terms. All very important. So what are key components that should be addressed when drafting IP licensing agreement? Let's see how well they were listening.
We have 5 minutes until the end, so I think I hope.
Getting down. We've got 70 slides we've gone through, or 70 different tests and slides. Indicate a specific duration and condition for termination of the license. Neglect to specify the governing law applicable to the agreement. Establish a payment structure outlining royalties and fees. Include a clause allowing unrestricted usage by third parties. Ooh. Clearly define the scope of rights and limitations. So some of these seem highly unlikely. We'll let you decide. What are the key components that should address should be addressed when drafting the IP licensing agreement?
I think this is a great question already at the end of the presentation because it summarizes so much that we have studied with you.
And I will make sure that you have a copy. So there are 3 things in here. And obviously the other 2 would be, or should be obvious. The ones that we should not include would be to neglect to specify the governing law applicable to the agreement, or include a clause allowing unrestricted use by third parties. Obviously, those would be out. To indicate a specific duration is good. To establish payment structure, obviously, and then clearly define the scope of rights and limitations are all really good to have in your contract. So we can leave it at this. I do have a little time if you want to. Do you have other questions or comments?
No, there is no more questions yet. So, and we have we have like 4 minutes left. So if you have maybe one last slide or something to say, and then we need to wrap up.
Let's see who's up there. We've got Ivan. Great job on that. And common pitfalls of IP agreements are failing to clarify or clearly define rights and obligations can lead to disputes. Ensure that all parties understand ownership, usage rights, and limitations. Miscommunication or vague terms can lead to unintended infringements or disputes over royalties and licensing terms. So if you remember, I had this as a checklist of things that we were going to do. I think we're right down to the very last minute or 2, but we'll see how you guys do on this. Making the agreement as lengthy as possible is the first answer here. What are the key factors to consider when drafting an IP licensing agreement to minimize misunderstandings? Obviously, omitting dispute resolution mechanisms, avoiding any mention of payment structures, include personal opinions about the parties, or clearly defining the scope of rights granted. That one should be very straightforward.
Especially including personal opinions about the parties. So yeah. I could really see you making it up.
That would be AI, I think. That would, it could easily, they call it hallucinate when it creates fake news. So those are some of the things that we're gonna talk about coming up in our next sessions. Is how do we protect against the upcoming types of technologies and intellectual property challenges that are out there, including new kinds of laws or new areas of law. So clearly the scope, and I think Ivan's, oh, nope, Dimitri just took over. So Dimitri just upstaged you on the very last question there. Ivan.
Okay.
Oh, well, thank you.
Yes, we need to wrap up. And I think today, AHA was wonderful. We were so much stressed last time with the new technology. So today it was wonderful. And thank you very much, Dan. It was a great webinar. And I wanted also to clarify that we are going to have some extra exercises, like extracurricular activities, let's put it this way, in between the sessions. So our next session is going to be on the 6th of November, and it's going to be dedicated to electronic commerce and intellectual property. So it's totally new and very specific topic. And in between, over these 2 weeks coming, we're going to study with you vocabulary in our Telegram and in other social media that we have. And also we are going to do some exercises and extracts from contract that Dan sent to me, and I will cut it into pieces and I will be giving it to you so we can revise the vocabulary again and again. So, which will be pretty cool, I think.
Very good.
Yes. Thank you very much, Dan, once again. We really appreciate everything that you are doing and are extremely grateful. And who is the winner out of in our today's session? Or let's name maybe the first 3.
Okay, we have Dimitri, IP, and that's 1,205 points. We have Dasha, which is 1,183, and Dan, not me, 1,139, and Ivan is the fourth one on the list here at 1,119. Congratulations! It's been a lot of fun. We're getting this down. I think we're gonna really do some wonderful things with this
Yes.
software.
Thank you very much, and see you in 2 weeks. Okay. See you, and bye-bye, everyone. And we'll see you in 2 weeks on the 6th of November.